Good morning, everyone. Really pleased to be here to be able to talk to you about what we've got happening in New Zealand with restorative justice and a lot of our restorative practices that are kind of interwoven within our justice system. I just want to start with a traditional Māori greeting. So, ko ranganui kei runga, ko papatuanuku kei raro, ko ngā tangata kei wainganui, tihei mauri ora. Papatuanuku te whaia, tēnā koe. E te whenua te tūranga o te iwi, tēnā koe. E te whare e tūnei, tēnā koe. E ngā tangata whenua o tēnei rohe, ngā tangata Algonquin, tēnā koutou, tēnā koutou, tēnā koutou. Tēnā koutou I o tātou tini mate, haere, haere, haere. Āpiti hono tātai hono rātou ko wehe atu ki te pō. Āpiti hono tātai hono tātou e tū ana ki te ao. Ki te tahua te Ture Kanata, te Collaborative Justice Program, me te Church Council for Justice and Corrections, I tono mai nei a hau ki konei, tēnā koutou, tēnā koutou, tēnā koutou. Ka nui te koa me te hari ki te tūtaki I a koutou, ko tai mai a hau ki te tautoko ki te kaupapa nui o tēnei hui. E tika ana te kōrero o tātou tupuna, nau te roro, nāku te roro, ka ora ai te iwi. Nō reira, tēnā koutou, tēnā koutou, tēnā koutou katoa. So I first acknowledge the Sky Father above and the Earth Mother below. I again greet the Earth Mother, I greet the land, the standing place of the nation, and the building that we're in. I acknowledge the Indigenous people of this area, the Algonquin people, and I thank you. I acknowledge those who have passed before us, as without them we would not be here, and I farewell them into the night. I then return us to the living. I thank the Canadian Department of Justice, the Collaborative Justice Program, and the Church Council for Justice and Corrections for inviting me here to support this really important topic. And I finish with a proverb, that by combining your food basket and my food basket, the people will live. That is, by sharing our knowledge and experience, great things will be achieved. So finally, greetings to you all here today, and thank you very much for having me. So in New Zealand, there's a Māori whakatauki, or a proverb, which says, he aha te mea nui o te ao. What is the most important thing in the world? He tangata, he tangata, he tangata. It is people, it is people, it is people. This whakatauki underpins our restorative justice practice in New Zealand. And I'm really pleased to talk to you about restorative justice and some of the other services that align with the restorative principles in New Zealand, and to share our experiences with you. So I'd like to start by talking about the evolution of restorative justice in New Zealand. Restorative practices were inherent in Māori culture. Before any enabling legislation, even before European settlement, New Zealand's Māori population used restorative practices. These practices were developed from their customs and traditions. The emphasis was on involving the whole community, on reaching a settlement acceptable to all parties, on examining the wider reasons for the wrong that was committed, and on restoring balance and harmony. When New Zealand looked to incorporate restorative practices into legislation, governing the criminal justice process, traditional Māori practice, including the involvement of the wider community in addressing harm to the community, was an important influence. A restorative type practice was first included in legislation for youth. The enactment of the 1989 Children, Young Persons and Their Families Act, which introduced family group conferencing, allowed, where possible, the concept of restorative practice to be built into the delivery of youth justice. Family group conferences. Although the term restorative justice was only explicitly introduced in the 2017 legislation changes, one of which was to change the name of the Act to Oranga Tamariki Act, meaning well-being of children. The intention of this Act was to increase the involvement of families and their wider circles when dealing with children and young people who allegedly offend. Child offenders are generally dealt with in the family court on the basis their offending is caused by lack of parental care and protection. Child offenders aged 12 and 13 can be going through the youth court if they're charged with a serious offence, such as murder or manslaughter. Offenders aged 14 to 16 years old are called youth offenders. They go through the youth justice system, which can include being charged in the youth court. Legislative reforms passed earlier this year will increase the age of youth offenders to include 17-year-olds by 2019. Those serious offences will still be dealt with in the adult jurisdiction. The Oranga Tamariki Act introduced family group conferences. So these are structured meetings where children or young people and their family, or whānau, which is the Māori concept of wider family, and professionals come together to talk about concerns that are held for a child or young person and develop a plan to address the issues. There are two types of family group conferences: care and protection, held when there are concerns for the safety or well-being of a child or young person, and youth justice, held when a child or young person has offended. And I'll talk a little bit more about youth justice conferences later on. In the early 1990s, the family group conference model was used in some adult cases. Trained community groups facilitated conferences and provided reports on individual cases to sentencing courts, where judges, using their discretion, had granted adjournments for a restorative conference to be held. No commitment was made that the process would affect the outcome, and judges were not obliged to consider the conference report in their sentencing decisions. Still in the 1990s, the first government-funded pilot of restorative justice criminal cases occurred. The 3-year pilot was carried out in 4 courts across 3 cities. The pilot built on the family group conference from the Oranga Tamariki Act, as well as the community-based programs carried out by volunteers. Evaluation results were positive, leading to the extension of government funding beyond the pilot courts. Eventually, restorative principles and procedures were incorporated into New Zealand's legislation. The statutory recognition of restorative justice within the criminal justice system was through the Sentencing Act, the Parole Act, and the Victims' Rights Act, all enacted in 2002. Together, this suite of legislation achieved 3 things. Firstly, it gave greater recognition and legitimacy to restorative justice processes. Secondly, it encouraged the use of restorative justice processes wherever appropriate. And thirdly, it allowed, and in fact required, restorative justice processes to be taken into account in the sentencing and parole of offenders when a conference had taken place. And then an umbrella organisation for restorative justice was established. In 2005, government funding was made available to establish a professional body to represent providers of restorative justice services. Restorative Justice Aotearoa, since named Restorative Practices Aotearoa, became an incorporated society. Its role is to help build practice among restorative justice providers, raise the profile of restorative justice, and contribute to the current and future direction of restorative justice. This society works very closely with the Ministry of Justice. And then a legislative amendment substantially increased restorative justice cases. In 2014, a significant amendment to the Sentencing Act was made. It stipulated that in specified cases, courts must adjourn criminal proceedings prior to sentencing to consider whether restorative justice would be suitable in the circumstances of the case, and if so, to adjourn the case to allow the process to happen. A restorative justice conference does not have to proceed if the case is not appropriate. But almost overnight, this legislative amendment quadrupled adult court referrals to restorative justice. Courts now refer around 13,000 cases to restorative justice annually, with around 3,000 cases proceeding to an RJ conference between the victim and offender. So before I go any further, it might be useful to just explain what restorative justice actually looks like in New Zealand. Firstly, I'd like to share how we describe restorative justice. So restorative justice is a community-based approach to responding to crime that aims to hold offenders to account for their offending and, to the extent possible, repair the harm caused to victims in the community. Ministry of Justice funded restorative justice aims to give victims a voice in the adult criminal justice system and may enable them to receive answers, apologies, and reparation. Participation in restorative justice is voluntary and usually involves a facilitated face-to-face meeting between the victim and offender. And this is how restorative justice looks in practice. Prior to sentencing, the facilitator meets separately with the victim and offender to work out if they're both willing to participate and that everyone will be and feel safe. Where the case involves family or sexual violence, only specially trained and accredited facilitators are used. Once these meetings have been conducted, the facilitator decides if a conference should go ahead. If the case is not suitable to proceed, the facilitator will inform the court and the offender will be sentenced as usual. If the case is suitable, the facilitator will bring everybody together for a conference. At the conference, the facilitator brings together the offender, the victim or victims, their support people, and if agreed, any professionals such as police, lawyers. Everybody has an opportunity to speak openly and honestly about how the offending has affected them. Parties may also discuss ways for the offender to help put things right. Putting things right might include the offender agreeing to attend a program, so an alcohol program or a family violence program, pay reparation, or volunteer in the community. The facilitator then reports back to the judge on the conference and any agreements made. The judge sentences the offender, taking into account the offender's participation in restorative justice in the facilitator's report, alongside any other information, such as a pre-sentence report. So the New Zealand government has been very supportive of restorative justice. As I already mentioned, several pieces of legislation supported the evolution of restorative justice. Firstly, the Sentencing Act 2002. This explicitly gave the adult courts the power to adjourn a case to enable a restorative justice process to occur, or to enable a restorative justice agreement to be fulfilled. This was a big step that gave recognition to the importance of restorative justice in the criminal justice system. Next, the Victims' Rights Act 2002 gave victims the right to request a restorative justice process in relation to the offence committed against them. If satisfied that the necessary resources were available, court staff, police, or probation were required to refer the request to a suitable service provider. The third piece of legislation was the Parole Act 2002. One of the guiding principles in this Act, which relates to the release of an offender from prison, ensures that any restorative justice outcomes are given due weight. The Act also allows for offenders on home detention to leave their residence to attend a restorative justice conference, and also to carry out any undertaking arising from a restorative justice process. And there was additional support over and above these pieces of legislation. Additional public and political support came from a review of victims' rights in 2011. The Victims' Rights Review was informed by a public consultation process which started in 2009 and involved consultation with key stakeholders and government agencies and information from local and international research and surveys related to victims and victims' issues. The review of victims' rights resulted in a range of operational and legislative recommendations, one of which was to provide better access to restorative justice processes. This recommendation reflected feedback received during the consultation process. For example, the following comments about restorative justice were made in some of the submissions received. Restorative justice is very important to families and whānau as a means of healing rifts between the community and families, and rifts within family or whānau. And the submitter is committed to principles of restorative justice and is very aware of the benefits many victims have gained in participating in well-facilitated restorative justice settings. Restorative justice, while being limited by the relatively small minority of victims of crime who will be able to take part, does offer a powerful tool that can offer victims the opportunity for finding safety, answers to questions, opportunities for truth-telling, and restitution. At the same time, submissions raised concerns about some factors, including whether enough government funding was made available so restorative justice could be implemented and delivered adequately, and ensuring it was victim-focused as opposed to offender-focused. The outcome of the review was that the government approved a package of reforms, one of which was the change to the Sentencing Act, which strengthened the use of restorative justice as part of the sentencing process. The bill was passed in 2014 and came into effect in December of that year. The feedback from the public, and in particular the confirmation that the environment was ready for a shift towards a more restorative approach, gave policymakers the confidence to be more innovative with the suggested reforms, and gave solid foundation to the successful implementation of the new legislation. And there was also monetary support from the government. From the funding of the restorative justice pilot in the 90s to the funding of the umbrella organisation in 2005, the government is now allocating $9 million New Zealand dollars, about 8 million Canadian dollars, annually to restorative justice services. This is a substantial investment for such a small country with a population of only 4.5 million. So the 2014 legislative amendment changed the landscape of restorative justice in New Zealand. The legislative change increased access to restorative justice in the adult jurisdiction in New Zealand almost overnight. The amendment to the Sentencing Act outlines when the court is required to adjourn criminal proceedings for consideration of restorative justice. Previously, the court's power to adjourn proceedings for a restorative justice process to occur was discretionary. The legislative amendment now requires a court to adjourn for an investigation into restorative justice where the following 5 conditions are met. First, that the offender appears before a district court for sentencing. This legislation doesn't relate to the higher courts. Secondly, that the offender has pleaded guilty. Thirdly, that there are 1 or more victims of the offence. Fourth, that no restorative justice process has previously occurred in relation to this particular offending. And fifth, that the court registrar, the administrator of the court, has informed the court that an appropriate restorative justice process can be accessed. So this is the New Zealand process for a referral to be made. A guilty plea is entered. A finding of guilt rather than a guilty plea doesn't preclude restorative justice from happening if it's considered appropriate. However, it's not covered under this section of the legislation, and it would be rare for a case to proceed to a conference if the offender hadn't pleaded guilty. The court will then assess the case against the criteria set out in the Sentencing Act. If the criteria is met, the court must adjourn the case to assess whether restorative justice is suitable. If it is considered appropriate for the case, the legislation further requires the court to adjourn the case for the process to occur. At the completion of the process, the facilitator submits a report to the court detailing the facts of the conference and any outcomes agreed, and any progress towards those outcomes. The court must then take the report into consideration when determining an appropriate sentence. So the purpose of the amendment was to ensure more people would have access to restorative justice services, and this was achieved very quickly. In the 3 months before the amendment, court made just over 1,300 referrals to restorative justice in the adult jurisdiction. In the 3 months after the amendment, courts made over 3,500 referrals. It's an increase of 169%. Looking at this from the wider viewpoint, in 2015, around 18% of all people convicted in a district court in New Zealand were referred to restorative justice. As well as the significant increase in referrals to restorative justice, we also saw an increase in the number of conferences held as a result of these referrals, from 465 in the 3 months before the amendment to 620 in the 3 months after. So the number of conferences has increased at a lower rate than the referrals, but we'd expected this to a point because there's many reasons that conferences don't go ahead. Most likely reasons are that either the offender or the victim doesn't want to participate, or that the facilitator has considered that it's not suitable or safe for an individual case. Evidence shows that restorative justice reduces reoffending and satisfies victims. Even though restorative justice was now provided for in legislation, evidence of its effectiveness was required in order for it to be accepted as a mainstream part of the criminal justice process. The Ministry of Justice has undertaken research and conducted studies to gather evidence from both the victim and offender perspective. So first, the research on reoffending. The Ministry of Justice has conducted 3 studies that look at reoffending rates for offenders that participated in restorative justice. The most recent study, which was released in 2016, included data from conferences held between 2008 and 2013. The method used in the reoffending studies was to compare offenders that participated in the restorative justice process to a matched comparison group of offenders who went through the police diversion or court process and would otherwise have been eligible for restorative justice. 4 key findings from the study include that the reoffending rate for offenders who participated in restorative justice was 15% lower over the following 12-month period than comparable offenders, and 7.5% lower over the following 3 years. Offenders who participated in restorative justice committed 20% fewer offences over 3 years. Restorative justice appeared to help reduce reoffending across many offence types, including violence, property abuse or damage, and dishonesty. There was no significant difference for participants who committed a driving causing death or injury offence, but the reoffending rate for this type of offence is low anyway. And restorative justice is effective for New Zealand's Indigenous population. The reoffending rate for Māori who participated in restorative justice was 16% lower over the following 12-month period than comparable Māori offenders. Māori offenders who participated in restorative justice committed 23% fewer offences per offender within the next 3-year period than comparable Māori offenders. Impacts of the 2014 legislation amendment have not yet been measured through a reoffending analysis, as there's not yet been time for the effects to occur. But work is now starting to assess whether the legislation changes has had any impact on these reoffending rates. In our research from a victim's perspective, in 2011 and 2016, restorative justice victim satisfaction surveys were undertaken with victims who had attended a Ministry of Justice-funded pre-sentence restorative justice conference. The results were very positive. The 3 significant results from the 2016 survey were that a large majority, so 84%, were satisfied with the conference they'd attended. 80% said they were satisfied with their overall experience of restorative justice, and 81% said that they would be likely to recommend restorative justice to others. Of interest, when we break the figures down, family violence victims were more satisfied with the restorative justice process than victims in non-family violence cases. And I'd like to share some of the comments that survey participants made. The first example I've chosen reads as follows. Both families got to come together as one. We got to talk about the necessary things that needed to be talked about. For instance, my mum got to express herself. I got to express myself. And the offender, their auntie and grandmother got to express themselves. We all got to say our own individual opinions and how everything had been going and how everything could go and how we could do things as a family. Closure. It was very comforting. I got to know where I stood as a victim, as a family member. For me, I had a lot of weight on my shoulders before the meeting and a lot of thinking. For me, it was the weight was lifted. And the second comment I'd like to share with you. Just having the opportunity to confront the offender is a good thing. And having that confrontation in a controlled manner, rather than confronting them in a supermarket or while walking the street. After going through the court process, the offender paid the penalty through the court process for their actions, but they're still part of the community, and we'll have to face them in the community. So restorative justice is a good icebreaker. One thing I liked was the opportunity to challenge the offender, to own the responsibility of what they've done, and make changes in their life for their own destiny, and take ownership. So 3 years on from the Sentencing Act amendment, our focus is on delivering an efficient, high-quality national restorative justice service. One of our challenges is to reduce the number of referrals to restorative justice in cases that are unlikely to proceed to a conference. Finding a solution to this gap will reduce unnecessary administration for courts and providers and minimise delays in sentencing offenders. One of the ways we're doing this is by improving the quality of information given to providers at the time of the referral, so that better assessment can be made earlier and better contact information is provided. And we're also focusing on the quality of restorative justice services delivered by service providers. In 2004, the Ministry published a document entitled Restorative Justice Best Practice in New Zealand. This document provided guidance on the use of restorative justice processes by outlining the fundamental principles that should be upheld within restorative practice. The development of these principles followed consultation with restorative justice practitioners, and it's a contractual requirement for Ministry of Justice-funded restorative justice providers to adhere to these principles. In 2013, specific standards were developed by the Ministry for restorative justice practitioners to follow in cases of family violence or sexual offending. These standards recognise that, while the principles outlined in 2004 provided a sound basis for the practice of restorative justice, additional safeguards are necessary when dealing with harm which has had complex or chronic impacts, such as family or sexual violence. The Ministry of Justice is currently reviewing these best practice documents in consultation with restorative justice practitioners to ensure that the guidance is still relevant. The first and foundation of the suite of documents, Restorative Justice Best Practice Framework, has now been published. The new framework sees the structure of the best practice documentation substantially overhauled. The framework now comprises of a guiding whakatauki, the Māori proverb that I mentioned earlier. It conveys the core purpose of the framework. The restorative justice values have been refreshed to reflect Māori restorative justice values proposed by our provider group, and standards have been developed to be used in all cases. The principles have also been streamlined. The principles that guide restorative justice practice are that participation is voluntary throughout the restorative justice process. The victim and the offender are the central participants in the restorative justice process. Understanding is the key to effective participation. Offender accountability is the key to the restorative justice process. Restorative justice processes are flexible and responsive to the needs of participants. And restorative justice processes are safe for participants. Currently, we're undertaking a review of the family violence standards, and after that, we'll be looking at the standards for sexual offending. In 2014, we entered a contract with a national organisation to deliver restorative justice training and to grant professional accreditation to facilitators working within ministry-funded organisations. Our contracts with service providers will soon require that all facilitators delivering services must be accredited for the services they deliver. Our current transitional contractual requirement is that facilitators are trained and working towards their accreditation. Being accredited as a restorative justice facilitator means the person has the skills to facilitate the restorative justice cases. It means that facilitators have had the training, mentoring, and guidance to perform the facilitator role. In addition to standard accreditation, facilitators can be endorsed for specialist expertise. The endorsements are for family violence cases and for sexual violence cases. Advanced accreditation is also available, which recognises facilitators who work on complex cases and who supervise and mentor others. The advanced accreditation was introduced in 2015 to provide a professional pathway for restorative justice facilitators and to give recognition for the skills and experience they gain through the years of practice. Looking across the justice sector, restorative justice is also funded at the post-sentence stage. But this is through a limited budget held by the New Zealand Department of Corrections, who administer New Zealand's prison and probation services. Post-sentence restorative justice can occur if the parole board has made a specific recommendation for restorative justice to be assessed as part of a prisoner's release plan. Some community restorative justice providers also provide post-sentence restorative justice services outside of those funded by the government using their alternative funding streams. The Ministry of Justice, through its joint work across the justice sector with police and corrections, have also explored other restorative practices in the youth, criminal and civil jurisdiction. New Zealand has various mediation services offered in the civil jurisdiction, such as in the family court and the employment court, but I'm not going to go into those today. Instead, I'd like to focus on services that are working to address the fact that Māori and Pacifica are overrepresented at all stages of the criminal justice system. The term Pacifica refers to migrants from the Pacific region and their descendants who call New Zealand home. In New Zealand, Māori represent 15.5% of the general population. However, Māori women make up 56% of the adult female prison population, and Māori men make up 50% of the adult male prison population. Māori also make up 60% of offenders under the age of 20 that are in prison. In the youth jurisdiction, significant legislation changes passed in July 2017 are driving youth justice reforms. As mentioned earlier, the amendments to the Oranga Tamariki Act 1989 will see 17-year-olds move into the youth justice system. There will also be significant enhancements to the system to make it more child-centred, trauma-informed, and focused on improving the outcomes of Māori. These changes also strengthen the need to consider restorative justice outcomes when delivering family group conferences. The adult justice sector is working to address overrepresentation through programs supported by Māori strategies within departments, co-designed with Māori or delivered by Māori. To prevent Māori and Pacifica from entering the justice system, there is a growing emphasis on early intervention, which incorporates elements of Māori culture and customs, such as iwi panels. In the court process, the Rangatahi and Pacifica courts and the Matariki court aim to deliver culturally inclusive services and incorporate appropriate cultural components to result in better outcomes for their participants. I want to speak about these services as you'll see many concepts familiar with restorative practice woven through them. Because many of these services incorporate parts of Māori culture, te reo Māori, the Māori language, terms are often used. And I'll make sure I give you the translations for these as I go along. So we begin with family group conferences. In the 1970s and 80s, the New Zealand government acknowledged the overrepresentation of Māori children and youth in the state care system. Following extensive consultation across iwi, tribes, and community, in 1989, New Zealand adopted new legislation, the Children, Young Persons and Their Families Act, 1989, now called the Oranga Tamariki Act, 1989, which established new objectives and principles for youth justice and set up an innovative system for responding to children and young people who offend. The new system emphasises diversion from courts and custody. While holding the child or young person accountable, the system supports the child or young person, their family, the victim, police, and other youth justice professionals to make collaborative and consensus-based decisions to address the underlying cause of the offending. The key mechanism for this is the family group conference, a culturally appropriate and effective process that involves families and their wider communities in problem solving. This system has been hailed as a positive example of a restorative approach that could be used to respond to alleged offending by children and young people, both because of its objectives and principles, and because of its use of family group conferences for informing responses to the outcomes of more serious offending by young people. Oranga Tamariki is the government agency that runs the statutory care and protection and youth justice functions, including youth justice residences and provision of therapeutic programs and supports. When a young person offends, the police can respond by, and this is from least to most severe, either issuing a warning not to reoffend, arranging informal diversionary responses after consultation with victims, families, and the young people. We're intending to charge, making referrals to Oranga Tamariki for a family group conference, or arresting and laying charges in the youth court. If there is an intention to charge or charges are laid in the youth court, the matter will be referred for a family group conference. The family group conference is organised and facilitated by a youth justice coordinator employed by Oranga Tamariki. Youth justice coordinators are the managers of the youth justice family group conference process. They are responsible for preparing children and young people, their family and whānau, victims and others for the conference, and ensuring the conference has all the information it needs to make good decisions. They also ensure the conferences are facilitated in accordance with the guiding principles in the Oranga Tamariki Act, and with participation by children and young people, family or whānau, and victims, while ensuring the interests of public safety are also considered. Family group conferences enable those involved in the life of the young person and the victim of offending to be involved in decisions that aim to ensure accountability, repair harm, and enhance the well-being of the child or young person. In addition to involving the child or young person, an effort's made to include as many of his or her family members as possible, including extended family members, and any professional caregivers who have been involved with the parties. Victims are invited to attend or participate in another way, and can bring support people or send a representative in their place. A representative of the police is also present. Other attendees may include the lawyer or advocate, social worker, Māori iwi representatives, so tribal representatives, or legal caregivers. Generally, there are three parts to a family group conference. These are getting the facts, talking, and making a plan. The facts of the offence are given by the police. If the young person does not agree with their account of the offence, the matter will be directed back to the police, or if a charge is already laid, then it will be referred to the youth court for further action. There's then an opportunity for the young person, the victim, and the young person's family to openly discuss the impact the offence has had on them. The victim can talk about what they think should happen and what the young person can do to make things right. A plan to put things right is mapped out. Plan should be fair to the victim and help the young person learn from their mistakes. The young person is given an agreed time and encouragement to complete the plan. If the young person does complete the plan where the police intended to lay a charge, the police will take no further action. If the young person is before the youth court, they may receive a discharge as if the charge was never laid. This means that the young person can enter adult life with a clean slate or a second chance. If the plan is not complied with, the court will step in and impose an appropriate order. The court will prefer plans that respond to victims and keep the young person in the community, where public safety doesn't require otherwise, and enhance their well-being. Evaluation has shown that the system is largely successful in achieving its goals, and when they're met, in reducing reoffending and promoting the well-being of young people who have offended. The design of the New Zealand youth justice system has contributed to a reduction in youth offending by 31% since the middle of 2011. The increased use of restorative processes and impact on youth justice outcomes was one of the reasons that New Zealand government decided to raise the age of the youth justice system to include 17-year-olds. As I said earlier, the concept of family group conferencing in New Zealand and widespread acceptance for this, that this was an appropriate and effective way to work with children and young people who offend, paved the way for the adult pre-sentence restorative justice service that we have today. Rangatahi and Pacifica courts complement the family group conference process. Rangatahi courts are a judicial initiative operating within the youth court. Rangatahi is the Māori word for youth. Rangatahi courts use a Māori-specific environment to try and help young Māori and their whānau, or family, engage with the justice system in ways that make sense to them, to hold them accountable for their offending and drive a long-term reduction in reoffending. The Pacifica courts run on a similar model, adapted for Pacific Island cultures. The first rangatahi court was launched in 2008. This has since expanded to 14 rangatahi courts around the country and 2 Pacifica courts based in Auckland. The rangatahi court is not a separate system of justice. It works within the existing legal framework, but uses tikanga Māori, which roughly translates as the correct way of doing things, and a marae, a Māori meeting house, as a venue. It's open to all young people appearing in the regular youth court, not just Māori, and allows those who admit the charges they're facing to have their family group conference plan monitored on a marae. After the family group conference has decided on a plan, the young person can choose to have this plan monitored by the rangatahi or Pacifica court. This means that all court appearances, until the plan is completed, will be held on the marae or at a Pacifica venue. Normally, the young person will appear at the court every 2 weeks, and each hearing will usually involve the same judge. A typical hearing at a rangatahi court will start with a pōwhiri, or a welcome or calling, of manuhiri, visitors, onto the marae. A morning tea will be served. The hearing of each young person's case then starts. Each hearing begins with the young person receiving a mihi, or a greeting, from the kaumātua, the elders, showing respect to that young person and acknowledging their whānau, hapu, and iwi links, so their extended family, their sub-tribe, and their tribal links. Also at the hearing will be the judge, police, kaumātua, the elders, social worker, court staff, whānau and family, a youth advocate, which is the young person's lawyer, a lay advocate, so a person of standing in the young person's community, and the victim if they choose to attend. During the time that the young person attends the rangatahi court, it's expected that they'll learn their pepeha, their traditional greeting of tribal identity, with the assistance of their lay advocate. At each hearing, the young person will practice delivering their pepeha. The young person may also be encouraged to attend a tikanga wānanga, so a place of cultural learning, to help them learn more about their cultural identity. So this is an image taken outside a marae before the rangatahi court is in session. And here's a photo taken during the rangatahi court, so you can see what the marae looks inside. A typical Pacifica court hearing will involve a briefing between the judge and the elders to discuss how each young person is progressing with their plan. Each case will start and end with a prayer. An elder that's from the same cultural background as the young person will talk to the young person and their family, offering encouragement and guidance. Assessment of the rangatahi court's effect on reoffending rates has been completed. This initial research indicates that participants committed 14% fewer offences and were 11% less likely to commit new offences in the following year. The rangatahi courts have been recognised locally and internationally, receiving the 2016 Institute of Public Administration New Zealand's Excellence Award for Crown Māori Relationships, and the Australasian Institute of Judicial Administration's 2015 Award for Excellence in Judicial Administration. In the adult jurisdiction, in recognition of the need to address the poor statistics on Māori justice outcomes, the Justice Sector Leadership Board commissioned a project in mid-2014 to explore a partnership between justice sector agencies and Māori organisations. The Partnering to Reduce Offending and Victimisation project was created and received funding from across the justice sector. A key element of this project was the creation of 3 iwi justice panels to be piloted as alternatives to a police charge in certain cases. As mentioned earlier, iwi is the Māori word meaning extended kinship group or tribe. Iwi panels tested a partnership approach to service design and delivery that involved and included Māori. In addition to being a catalyst for engaging with Māori more widely, the panels also aimed to reduce reoffending. Iwi panels are pre-charge panels comprising community members. Police exercise their charging discretion to refer adults who have committed low-level offences to these panels. Panels focus on repairing harm caused by the offence, using a problem-solving approach to address factors that contribute to offending. For example, panels may refer offenders to education or training programs and ask them to commit to good behaviour for a stated period. For Māori offenders, panels aim to build wider family support. After the completion of the panel process, a report is submitted to the police outlining the offender's compliance with the panel plan and providing a recommendation of whether to continue with the charging process. The majority of offenders who participate in the panel process are Māori, and the panel process incorporates elements of Māori culture and customs. Panels are open to people from all backgrounds, but have been found to be particularly effective in reducing reoffending for young Māori, aged 17 to 24, reducing their reoffending rates by 12% compared to a matched comparison group. There are currently 3 justice panels operating and 1 community justice panel. The Matariki Court is a specialist court that was established in response to the disproportionately higher number of sentences of imprisonment that were being imposed in a particular district court compared to other courts around the country. Matariki is the Māori name for the cluster of stars, also known as the Pleiades. It rises in midwinter and heralds the start of a new year. The Matariki Court is a post-guilty plea, pre-sentencing court that enables the iwi, hapu and whānau of an offender to address the court on the offender's cultural background, the extent to which this has impacted on offending, and actions taken to address the causes of offending. It's similar to the rangatahi court in that it also provides for the incorporation of culturally specific responses to offending. Central to the work and success of the court is an iwi-based group who assess the suitability of the offender for the matariki process, and then work with the offender, the victim and their whānau in the development of a plan to address the causes of offending. They have a pivotal role in not only linking the offender and whānau members with services, but also in providing iwi-based support and bringing whānau and family back together. The court approves a rehabilitation plan developed by the iwi provider in conjunction with the offender, victim and whānau, and defers sentencing while the plan is being actioned. When all parties are satisfied that the plan has been completed or that sufficient progress is being made against the plan, the matter is brought back before the court for sentencing. An initial evaluation of the Matariki Court shows a lower rate of reoffending over the following 12 months for those who completed the Matariki Court process compared to those who were removed from the court. However, the sample size for this is very small, and so the findings need to be used with caution for now. And finally, moving out of the criminal jurisdiction completely to look at a restoration on a national level. Treaty settlements in New Zealand have a clear focus on resolution and resetting relationships between Māori and the Crown. Treaty settlements in New Zealand refer to agreements reached between the Crown and a Māori community or group about a claim related to Te Tiriti o Waitangi, or the Treaty of Waitangi. The Treaty of Waitangi is widely considered to be the founding document of New Zealand. It was signed by Māori rangatira, or chiefs, and representatives of the British Crown in 1840. At the time, there were about 100,000 Māori living in New Zealand and only 2,000 Europeans, or Pākehā. The Europeans felt it was necessary to have a formal acceptance of their settlement and an assertion of British sovereignty over New Zealand. Māori signed the treaty for many reasons, including the mutual benefits British settlement would bring, protection of land and tribal position, the relationship with Britain and Queen Victoria, and protection from tribal violence and unruly British traders. There were two versions of the treaty, one in English and one in Māori. They're not exact translations of each other. Those who signed the treaty brought different experiences and understandings of certain words to the signing. When the British representatives took the treaty to different Māori groups, they possibly introduced it differently, and their explanations no doubt varied. The treaty incorporated a number of undertakings that were not fulfilled by the Crown, and Māori perceived a gradual but definite imposition of British law and institutions at the expense of traditional Māori law and sanctions. By the end of the 19th century, Māori had been told by the Chief Justice that their treaty was a nullity, with no standing in law. Not until 1975, when the Waitangi Tribunal was established to investigate treaty claims, did the treaty begin to be taken seriously. The Crown has now acknowledged that it breached the treaty in a number of ways, including land confiscation, execution or detention of prisoners without trial, failure to preserve lands for Māori, impact of native land laws, and the taking of land for public works. The Crown has accepted a moral obligation to resolve historical grievances resulting from its past actions that have been in breach of promises made in the Treaty of Waitangi. Settlements of historical claims are the Crown's way of making up for past breaches of the treaty and restoring good relationships with iwi. Aspects of the settlement process will be familiar to many people working in the restorative justice field. During negotiations, representatives of the iwi and Crown meet regularly to discuss the grievances and work out redress. The process includes agreeing a historical account detailing the ways in which the Crown breached the treaty, the Crown acknowledging and apologising for treaty breaches and the impact that these breaches had on the claimant group, and redress is provided by the Crown to recognise the losses suffered and restore the relationships. This could be financial or commercial, such as money or property, or cultural redress, such as changing place names or co-governance of rivers or lakes. The Crown apology and historical redress that are a part of each settlement process acknowledges the impact of historical Crown actions on iwi. In this way, the focus is on healing the past and building the future. So in conclusion, restorative practices in New Zealand have existed since pre-European times. When we looked to incorporate restorative practice into legislation, traditional Māori practice requiring community involvement was an important influence. Since the 1980s, we've continued to adapt, develop, and expand the use of restorative practices across our justice system. Such practices are now evident not just in restorative justice conferences, but also across the family group conferences, iwi panels, rangatahi and Pacifica courts, the Matariki Court, and in the Treaty of Waitangi settlement process. The Ministry of Justice in New Zealand is on a journey to provide people-centred justice services that deliver better outcomes for New Zealanders. We continue to work with our community providers to ensure restorative justice services are of a high standard and that the fundamental principles of restorative justice are upheld. The government has committed to $9 million annually to fund restorative justice services over the next 4 years. For a country of 4.5 million people, it's a substantial contribution. This continued funding recognises that restorative practices, which put people at the centre of the justice process, reduce reoffending, and improve outcomes for victims. People-centred justice means many things. It encompasses modern courts and tribunals to get people through quickly so they're not waiting years for their issue to be resolved. It means improved justice outcomes for Māori, reducing their overrepresentation in the criminal justice system and ensuring treaty settlements are completed effectively. It means there's less crime, victimisation and harm. And it means that all people who come into contact with the justice system are treated with dignity and respect. Restorative justice and many other services with restorative values make a strong contribution to these goals. So I'd like to finish with another proverb. E hara takutoa, he takitahi, he toa takitini. My success should not be bestowed unto me alone, as it was not individual success, but success of a collective. Nō reira, tēnā koutou, tēnā koutou, tēnā tātou katoa. Thank you very much for having me here today.